This is the case of the State of Ohio versus Tracy Cole, case number 24 CR 42147. Present before the court is Ms. Cole, right?
Yes.
Presented by Ms. Kirby. We have Ms. Hyatt from the Prosecutor's Office and Officer Bridgman from Probation. We are here today because your attorney has filed a motion requesting something called intervention in lieu of conviction. I assume we're going forward with that?
Yes, Your Honor.
What this means is, if I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to these charges, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes inpatient treatment in the STAR program. It's about a 4 to 6 month community-based corrections facility. Then you're going to be on supervision and do the aftercare when you're released. If you do all the things that you're supposed to do and you refrain from the use of drugs or alcohol during the treatment period, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do and you begin using drugs or alcohol, I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes.
How old are you, Ms. Cole?
52.
How far did you go in school?
Graduating?
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Yes.
Other than what we've talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Ms. Kirby before you signed it?
Yes.
Are you satisfied with the representation you've received in the case?
Yes.
You're going to enter a plea of guilty to 1 count of aggravated possession of drugs, 1 count of obstructing official business. These are each 5th-degree felonies punishable by up to 12 months in prison and a $2,500 fine. Even if you don't successfully complete the ILC, though, I don't have to send you to prison. That used to be the law. It's not the law anymore. I still have the option of putting you into my community control program, which is most people think of as probation. Before we go any further, Ms. Cole, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty, if they can. You have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights, you're going to admit that you did it, and we're going to get on to the matter of the ILC. Is that what you want to do?
Yes.
Ms. Hyatt?
Your Honor, if this case had proceeded to trial, the state would have shown beyond a reasonable doubt that with respect to counts 1 and 2, they both occurred on October 26th of 2024, while this defendant, Tracy Cole, was at her residence in Franklin, Warren County, Ohio. With respect to count 1, during the interaction with police officers at her own home, she did knowingly possess a controlled substance. In this case, it was 0.49 grams of methamphetamine, a Schedule II controlled substance. And with respect to count 2, while the officers were at her home, she did, without privilege to do so and with purpose to obstruct or delay the performance of the officers for to do any act within their official capacity. She did act in a way which hampered and impeded them from doing their duty at her home, and her actions caused a risk of physical harm.
Anything on those facts, Ms. Kirby?
Nothing on the facts, Your Honor.
Ms. Cole, did you hear those facts?
Yes.
Do you admit they are true?
They are
Do
true.
you understand the rights you're giving up by entering a plea?
Yes.
Which plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. I'm going to order that you enter into and successfully complete the STAR program, plus be on electronically monitored supervision with a curfew for 45 days after your release. And you are required to do all of the aftercare and anything that they say after that. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs, and you're going to be subject to random drug testing. Ms. Cole, so far in this case, you have had a serious focus problem, and your focus needs to be on recovery. That's the main reason that I'm taking you out of the community and sending you to a place with a lock on the door so that you can focus on you and your recovery. Then you can take care of the other things in your life. Okay?
If there's anything left, I'll do that.
I'm sorry?
Nothing, sir, that's all.
All right, good luck to you.
Your Honor, there was a $205 reimbursement I forgot
Oh,
to
yeah,
mention.
okay.
Thank you.
I'm going to have you sign this. This is-
Oh, did you want her on monitor after STAR, Judge?
45 days.
Oh, 45 days, I'm sorry.
That's all right.
45 days in EMS.
Yeah.
Okay. You good? All of a sudden I was worried, I'm thinking.
session, I don't look at presiding, proceeding.
All right, we're on the record, case of State of Ohio versus Tiffany Parks, Brittany Matthews, Derek Floyd, D'Amber Mitchell, Corey Matthews, and Zoe Matthews. Anything preliminary to come to my attention before we get started today?
Not from the state, Your Honor.
All right, Mr. Hardman, you may proceed.
Call Detective Casey Beheimer, Your Honor.
Just verifying the testimony you'll give for this proceeding, will be given at the minute for some time.
Yes. Detective, if you would, go ahead and give the court your name and spell it for our court reporter, please.
Casey Beheimer, Casey Beheymer.
And how are you employed?
I work for the City of Mason Police Department.
And what are your assigned duties with the City of Mason Police Department?
I'm a detective, so I investigate criminal cases. I also am trained to do digital forensics, meaning download of phones and computers and then do the examination of them.
And when you do those types of activities, are there tools and software that you use to assist in that?
Yes.
Talk about those tools, what you use in order to
There's multiple tools, so I utilize Celebrite Premium and Graykey, and those are tools that will image the device, and then Celebrite and also Magnet Axiom are used to then process and create portable cases that are then used to view the devices.
And in order to create a portable case is what gives you the ability to actually see what's in the phone, is that correct?
Yes.
Outside of turning on the phone and looking at the phone itself.
Yes.
Why use that process instead of just turning the phone on?
You do that in order to preserve the evidence, because if I were to go into the device and manually view it, there's potential that I would then alter some sort of evidence within the phone. So these the tools are used to not alter any of the evidence.
And are you familiar with an incident that occurred on August 24th, 2024 in the city of Mason at the intersection of Innovation Way and I-71?
Yes.
Were you aware that there were cell phones that were seized as a result of discussing with potential suspects of that particular crime?
Yes.
Now, at first, going back to August 24th, you weren't involved in actually the download and the creation of the cases on any of those phones, is that right?
Correct.
You became involved recently, sometime in February of this year, is that correct?
Yes.
Why is that? Why did you become involved?
The cell phones that were provided to you, there was a file that was missing, so you were not able to open the portable case. So I took the original image that was, it was imaged by the Department of Homeland Security. I took that original image and then I processed it again so that you were able to then view it.
And you processed that through a certain piece of software?
Yes.
And that was what?
Magnet Axiom.
I'm going to show you what has been marked as State's Exhibit number 31. Does that look familiar to you, Detective?
Yes.
What is that?
That's the magnet axiom of the cell phone.
That you analyzed and did sometime in February 2025?
Yes.
Which exhibit number is this?
31, Your Honor. I want to just point out real quick, so up in the, under case summary notes.
I'm going to object at this point to Exhibit 31. One, it wasn't disclosed. I know he's going to argue with me that the entire phone dump was provided. Again, that was provided only 2-3 weeks ago, 2.5 weeks ago, likely. I'm going to object to her further testimony at this point because I think we're crossing over into the range of an expert testimony. She's testifying that she had to receive specialized training using specialized software. We were not provided with any type of an expert report from this witness.
My take on this witness's testimony so far is that she is a records custodian. So she's testifying how the records came into her possession. I don't think that I have heard any expert testimony so far. So I'm going to overrule the objection with regard to Exhibit 31, I assume, Mr. Hardman, Exhibit 31 is just more information on the report that we were gonna see yesterday, right?
Yeah, this is the actual physical download of the phone, which has been provided to all council.
So I don't see the prejudice, but I also, I mean, it seems like it was the other exhibit that we need to get to, right? And this is
I'm
just
not gonna use that exhibit, we're gonna use this
oh,
directly
we're
from
just
here,
using the whole thing.
which is what the exhibit comes from because of what we're dealing with, so.
Okay,
Thank you, Jeff.
all right. Objections overruled.
Up in the top corner under case summary notes, there's a note there that talks about examiner name. Do you see that?
Yes,
And it indicates, it says NIFA Nick Deheimer.
yes,
That's not you, correct?
correct.
Can you tell us who that is?
That's my husband.
Okay. And as it relates to, you're the one who actually did this report,
Correct.
not your husband, correct?
Correct.
Any explanation for that?
My explanation is that at some point, he is also trained to do the cell phones, and at some point, he utilized our software at our police department to process another phone. And so when I processed this, I must have missed that the examiner name was him, because I'm usually the one person that does the exams, and so that was my error.
So upon this information, at this point, are you able to access the entire contents of the cell phone that you were looking at?
Yes.
And I want to look at, first of all, we'll go into this source here. Just tell us what we're looking at on this particular screen.
It is an overview of all of the contents of the phone.
And in the left column, there's a series of different headings. What are those and how do they pertain to the phone?
It's,
Before you answer, Detective, I apologize. At the end of this, I'm gonna get like a thumb drive with all of this. Is that gonna be the exhibit, or is there like a huge paper printout?
You're going to get a hard drive.
Okay, go ahead. Sorry, Detective.
on the left column, it's just different categories of various pieces of the digital evidence.
One of those things one of those columns that exists here is the operating system, correct?
Yes,
And there's another line that says owner information, correct?
yes.
And when I click on owner information, something pops up on the screen, is that correct? Tell us
Yes.
what we're looking at on the far right.
This shows the owner's information of the phone.
And who does that indicate the Apple ID belongs to?
Tiffany Parks 81 at iCloud.com.
And then there's a phone number that goes to that particular device as well, is that right?
Yes,
And it indicates that it's an iPhone.
yes.
Throughout the phone itself, are there multiple references to Tiffany Parks and user accounts with Tiffany Parks and emails with Tiffany Parks on them?
Yes.
If I were looking for text messages that would have been exchanged by this phone, where would I go with regard to this particular document or this particular?
Communication.
So as I go to communications, where would I go next?
iOS, iMessage.
And then that opens up, what it says matching results, 72,500 message results, correct?
Yes.
And that means what?
There are that many text messages within the phone.
And are
for
you
that
able,
app,
sorry.
in that specific application.
And are you able to filter that out to look for certain timeframes or individuals?
Yes.
So one being up here where it says date and time, is that correct?
Yes.
If I click on that, I can then set the time range for what I'm looking at.
Yes.
I'm going to go ahead and do all dates after August 23rd, 2024. And when I do that, does that change my matching results?
Yes.
And it should give me what?
All dates after August 23rd.
All the text messages that were,
Yes.
that would have gone to or from the phone during that time?
Yes.
So I want to look at a couple in particular. So, get rid of this preview file first. So let's just talk about the individual columns that we're looking at. They appear self-explanatory, but let's go ahead and talk about them. The first column says sender. What is that telling me?
That's the person sending the text message.
The next to that is sender name. What is that?
The contact name associated with the phone number.
Would every sender also have a sender name attached to it?
Not necessarily.
Does that depend on whether or not the user of the phone has put a name to that particular phone number?
Yes.
Next is a recipient. Can you tell us what that is?
That is the person that's receiving the text message.
Now, underneath that column, we see this local user reference. What does local user tell you?
That would be the owner of the phone.
So that means that the text message is either originating from that phone or going to that phone. Correct?
Yes.
Recipient name is what?
That's the contact name associated with that phone number.
Message sent date column.
That's when the text message was sent.
Message refers to what?
That's the contents of the text message.
Let's talk about status. What does that mean?
That is indicating that the text message was sent, received, or read, or not delivered.
And then message delivered would indicate what?
The date and time that it was delivered.
And the message read date.
It's when the text message was read.
I want to look specifically at a couple of text message chains. Starting first of all with this one that refers to the sender name as DeAmber. You see that?
Yes.
Now, when I click on that individual line, it can create this preview to the right. Is that correct?
Yes.
Does the line pertain to only one specific message, like the middle section?
It highlights it, but then you can scroll through to see the rest of the conversation.
So the preview is going to show me all of the conversations that occur between those two same numbers, correct?
Yes.
And so that's what we're looking at on the right side, correct?
Yes.
Let's go ahead and talk about, with regard to this message to DeAmber, the gray box would indicate a message coming from DeAmber, is that right?
Yes.
The blue box is the individual of that phone, is that correct?
Yes.
Starting at this text chain at this point seems to start on around 5:30 p.m. on August 23rd.
Yes.
I want to go through, and at about 2 a.m., there's additional conversation that starts up, correct?
Yes.
If you would, go ahead and read the messages that are coming from the phone starting at 2:01 a.m.
Fuck him. I don't care. He poured his drink on me.
Was there then a response from who's identified as DeAmber in the phone?
Yes.
And that is?
He about to try to drive home.
The phone then picks up from there and states what?
Girl, fuck him. He disrespectful. He poured his drink on me. Fuck him. I don't care. On everything, I don't care.
And that, does DeAmber then respond back?
Yes.
And that is?
I don't want the police to take your car. He said, ain't no plate on it.
And what is the response to that?
I pulled them plates off the car. TF, fuck him.
And then there is another response from DeAmber?
Laughed at, I pulled the plates off the car. TF, fuck him.
Now, would that have come in as laughed at on the actual phone,
Yes,
as like an emoji of some sort, or,
just a reaction.
okay. So that language wouldn't have been what was received by the phone, correct?
I'm
Correct.
to object at this point. Now she's crossing over the line. She's texting, now she's testifying to expert information. How does she know that without specialized training? She's not just a records keeper at this point. If there's a laughing emoji or a reaction emoji, whatever.
I mean, I don't think that she is testifying in an expert capacity. I think she is testifying as to what the records show, which is how this record would be on the phone that differs from what it is on the record, so I'm going to overrule your objection. With regard to the reading of the text messages, technically the text messages do speak for themselves, but I'm going to go ahead and let her read them just for ease in the examination, both direct and cross, so that that's just the easiest way to present them. But the evidence is not what she is saying about what the text messages say. The evidence is the text messages.
Understood.
Go ahead, Mr. Harmon.
There are then two more messages that come in. Well, let's first start with the first one. Does this come in from the phone as well?
Coming from the phone itself.
Yes.
That's my daughter, Car, don't disrespect me.
Now, there's a break in time between that one and the next message that comes from what is labeled as Tiffany Park's phone, correct?
Yes.
And what is that?
It says, girl, he spit on me.
And then did DeAmber respond to that?
Yes.
And that is what?
What's his number?
I want to look at these text messages referring to a sender named by the name of Chris Ty. Starting at 8/24/2024 at 8:10 a.m. Again, the gray is who?
Chris Ty.
And then the blue would be the phone that's labeled as Tiffany Park's, correct?
Yes.
If you would, go ahead and let's walk through that text
Your
message.
Honor, I object, lodge an objection as to hearsay with respect to Mr. Ty for the individual.
Agree, Your Honor.
I think at this point, I am only going to allow the evidence as to the one defendant, consistent with my previous ruling.
Go ahead, if you go ahead and read through those messages, please.
Your Honor, I'm confused. Did you sustain the objection?
What's that?
You're going to allow her to read Chris Ty's messages? We don't know who Chris Ty is, or if he's a human.
I'm going to allow this as evidence against the owner of the phone only because I think it is a reasonable inference from that. May not be a real person, but that goes to the weight, not to the admissibility.
Thank you, Judge.
Go ahead, Detective, if you go ahead and read through those messages.
Is the game still at NCH? No, at Caldwell Park. I'm sure, oh, I'm sorry, okay. Somebody said that yesterday and I had to make sure. Yeah, they lost that field. This nigga just spit on me. Who? Vinny, I'ma kill this nigga. Where y'all at?
And those messages started or end at 10:11 a.m., is that correct?
Yes.
There are additional text messages with Aunt, what are labeled as Aunt P. Vinny, is that correct?
Yes.
And again, we look at the same preview when we pull that up throughout the morning of August 24th, 2024.
Yes.
Nothing further. Thank you.
Respectfully, no cross, Judge.
No questions, Your Honor.
Mr. Hughes?
Give me just a second, Judge. With regard to Chris Ty, you don't know who this person is.
Correct.
You don't reach out and try to call or investigate any of these people, do you?
No.
In this phone, there are also some contacts, correct? Did you search the contacts?
No.
Did you look for Derek Floyd's name in the contacts?
No.
Did you look for Corey Matthews' name in the contacts?
No.
Did you look for DeAmber Mitchell's name in the contacts?
No.
Did you read any messages from Corey Matthews, or to or from Corey Matthews on August 24th?
No.
Did you look for or search for any contacts for Derek Floyd on August 24th?
No.
Any messages to DeAmber Mitchell on August 24th?
No.
No further questions, Judge.
Mr. Kramer?
No questions, Your Honor.
Mr. Bennett?
No questions, Your Honor.
Mrs. Strowski?
No questions.
Anything else for this witness?
No, Your Honor.
All right, thank you, Detective, you can step down. Next witness?
Call Detective Seacrest.
So we're from the testimony of the proceedings.
I did.
You may proceed.
Detective, will you please state your name for the record, please?
My name is Michael Seacrest.
And can you spell that for our court reporter, please?
MICHAELSECHRIST.
And how are you employed?
As a detective with the City of Mason Police Department
And how long have you been with the City of Mason Police Department?
for a little over 11 years.
And what are your current duties there?
I currently work as a police detective in the investigation section.
I heard you were promoted recently to sergeant, is that correct, or has that not happened yet?
So that'll take place April 6th.
All right, well, congratulations in advance.
Thank you.
How long have you a detective with the Mason Police Department?
About 2 years.
Were you working in that capacity back on August 24th, 2024?
Yes.
Did you become aware of an incident that occurred at the intersection of Innovation Way and I-71 in Mason?
Yes.
And did you become involved in some of that investigation?
Yes.
As part of that investigation, did you meet and have a conversation with Tiffany Parks?
Yes.
During that conversation with Ms. Parks, did you obtain any property belonging to her?
Yes.
And what is that?
Her iPhone?
I'm going to show you what has been marked as State's Exhibit Number 32. Can you identify that item for us, Detective?
Yes. This is her iPhone that I seized from her.
And that is currently turned on, is that correct?
That's right.
If you could, what did you do with that iPhone upon your receiving it?
So when I received the iPhone, I placed it in airplane mode just to preserve the evidence. And in having a conversation with her, her being Tiffany, she told me that if you get a search warrant, I'll give you my passcode. So within just probably a day or two, obtained that search warrant, went to the jail, served her copy. She gave me her passcode for her phone.
Did you then have it sent somewhere to have it downloaded?
Yes.
Where was that?
So working with the local Homeland Security office in Blue Ash, this phone was transferred to their custody for forensics.
When it got back to the Mason Police Department, did you have contact with that phone again at that point?
Yes.
What did you do with the phone at that point?
So at that point, we still had a open search warrant, so went through the phone, just checking call logs, text messages, photos, things like that.
With the phone on right now, I would just like you to, if you could, open it up for yourself.
Okay.
I'm confused. This is the same phone that we have the download of?
It is, I just want to make sure that that's what I'm trying to establish. If they're willing to stipulate that, we don't need to go any further than that.
Are we stipulating that the phone download, subject to your previous objections, is from this phone?
The phone download, yes. At this point, I have an issue because there's a chain of custody situation going on because he didn't have the phone. It's going out to Homeland Security. I don't know what happened to that phone and come back to this detective. But the phone dump, I have no objection to.
Okay.
With that
We're willing to-
clarification, I don't need 32, right?
I'm willing to accept that stipulation that that phone that you have is the one that was provided, that resulted in the download that is the magnet Axiom, correct?
Correct. I'm okay with that.
Thank you, nothing further.
Respectfully, nothing, Judge.
No questions, Your Honor.
Did you go through the download?
I did look through the download.
Okay. And in the download, did you search and find contacts for Derek Floyd?
As far as finding contacts for Derek Floyd, that would have been actually going through the phone itself.
Okay. Well, let's just ask that question. Going through the phone itself, you saw a specific contact for Derek Floyd?
So, I
Yes or no?
believe, I'm sorry?
Just yes or no, please. Yes or no, did you find a specific contact for Derek Floyd?
Are you asking specifically for that name, Derek Floyd?
Yes, sir.
So as far as that
Just a
specific,
yes or no. Yes or no, did you find a contact for Derek Floyd? Yes or no?
I'm trying to answer, I'm just trying to say,
Your Honor, can I direct the witness, please, to answer my question? It's a yes or no. I
Can
ask
you
anything
answer the
other than
question, yes or no?
There's
So,
no
Your
explanation
Honor-
Mr.
necessary.
Hughes, I don't want to go through this again today. I
trying to
raging
move this
yesterday. Nobody talks when I'm talking. Why can't you answer it yes or no?
Your Honor, I believe there was a nickname used that I learned was Derek Floyd.
Okay,
So that's the hesitation or the things of that nature.
okay, tell me about that.
So, short body is some sort of nickname or rapper name for Derek Floyd that I know is Derek Floyd. So that's what
How do you know that?
through an extraction on Derek Floyd's phone. That is a term that was found he uses for himself.
Okay.
So
go ahead,
yes,
Mr.
you found a specific contact for Derek Floyd.
Yes.
Yes or no, you found did not find that Chris Ty is Derek Floyd. Chris
I-
Ty is not Derek Floyd.
That's correct.
Okay. Same for DeAmber Mitchell. Do you find a specific contact for DeAmber Mitchell?
Yes.
And did you find a specific contact for Corey Matthews?
Yes.
Did you find a specific contact for Brittany Matthews?
Yes.
And you found a specific contact for Zoe Matthews?
Yes.
And none of them are Chris Ty.
As far as I know, none of them are
All
Chris
right.
Ty.
And you would agree with me that none of the messages that you've reviewed either in the phone or in the phone dump are Tiffany Parks saying, hey, guys, let's all get together and let's go hurt Vinny.
Correct.
None of them followed up with these messages that we just heard about, that I want to hurt Vinny or I want him dead, said, put a plan together to go hurt Vinny or to get him dead.
Can you repeat your question?
None of the messages from Tiffany Park's phone to anyone in the phone said, let's get together and go plan to hurt Vinny.
Correct.
None of them mentioned baseball bats.
Correct.
You agree with me in that phone, there's nothing, no evidence that said, let's go find him, or let's go look for him.
Correct.
No further questions, Judge, thank you.
Mr. Kramer?
No questions.
Mr. Bennett?
None, Your Honor.
Mrs. Strutsky?
No questions.
Anything else for this witness?
No, Your Honor.
Thank you. You can step down. Next witness?
We have no further witnesses, Your Honor.
All right. Exhibits?
We would move State's Exhibits number 1 through 10, which are all photographs. sorry, I keep
So-
going, I just, State's Exhibits number 1 through 10, State's Exhibit 11, which is the northbound facing video, State's Exhibit 12, which is the southbound facing video, State's Exhibit 13, which is the zoomed and combined videos from the scene, State's 14, the aerial view of the intersection, State's 15, I believe that's A through C.
I have A and B, but I don't know what C is.
I'm sorry, it is A and B. 15A and B, which are screenshots from Peggy's, Paulette Scales' phone. State's Exhibit 16 and 17, which are both ring videos from Paulette Scales' home. State's Exhibits 18 through D, which are images of Mr. Vinegar.
What's D? I don't have a note about D.
D is the me.
Okay.
I'm sorry, D is one of the 2 photographs at the hospital.
Okay.
State's Exhibit 26, which is Zoe Matthews' interview. And then State's Exhibit 31, which.
I'm sorry.
Wait, is it 27?
Sorry, 27, I got the wrong line. State's Exhibit 27, which is Zoe Matthews' interview. And State's Exhibit 31, which is the download of the Tiffany Parks film.
All right. Objections as to the exhibits?
Your Honor, may it please the court, as to Deanna Mitchell, no objections to the introduction of the exhibits.
Okay. And with regard to Ms. Mitchell, you did not continue in your line of questioning regarding the interview of Zoe Matthews, so that is not offered against Ms. Mitchell, right?
May it please the court, I started the line of questioning, then conferred with my client. I still think it should be offered against her for purposes of her defense.
Okay, so we want it to be right now, my note is that Mr. Kramer wanted it against Mr. Floyd, and Mr. Bennett wanted it against Ms. Matthews.
My client wishes to have it against her. We did discontinue our line of questioning, but we believe it's important for her defense, and we would like it against her as well.
Okay.
Thank you.
Any other objections?
None, Your Honor.
Mr. Kathman?
Judge, just objection to 31.
All right, the objection to 31 will be overruled. Mr. Hughes?
Same objection to 31, Your Honor.
31 will be overruled, and you did not want Ms. Matthews?
I have no objection to that being used against Ms. Parks as well.
Mr. Kramer?
No objection.
Mr. Bennett?
No objections, Your Honor.
Mrs. Straussky?
No objections, and I would submit that using Ms. Matthews' interview against my client would be appropriate, because she does point out that my client was being assaulted when people came to his aid, so I would like that to be used against my client as well.
I mean, we've sort of used the term against your client. Just, the evidence would be applicable to that defendant for, against. Okay. All right. Anything else on issues regarding exhibits? All right. So, 13. I guess nobody cares about 13. I mean, 13 is a modified version of 2 other exhibits. Nobody cares?
No objection, Your
Okay,
Honor.
they'll be admitted. All right, Mr. Lewis,
Is the state respectful?
you're done, right?
I am done, Your Honor. Say yes.
Thank you, Your Honor. May it please the court, at this time, on behalf of Deanna Mitchell, counsel would respectfully move for acquittal to counts 1, 2, and 3 pursuant to Rule 29 of the Ohio Rules of Criminal Procedure.
Everybody joins in that motion, right?
Yes, Your Honor.
Yes.
Okay, so everybody joins in the motion. If you want to just tell me anything specific about Ms. Mitchell?
Yes. Your Honor, for the record, again, the court has paid very close attention to the evidence and the presentation of the case. The language, I don't have to educate the court. There is no evidence that has been presented by the state, even looking at the evidence in the light most favorable to the state of Ohio, that Deamber Mitchell did attempt to purposely cause the death of Mr. Vinegar. Also, Judge, on August 24, 2024, that's clearly, in our opinion, Your Honor, grounds for Rule 29. Counts 2, looking at the evidence in the light most favorable, there's nothing that's been presented that Deamber Mitchell did knowingly cause serious physical harm to Mr. Vinegar on August 24th. And also to count 3, Your Honor. Again, it's court's aware of the law. You looked at the evidence. There's nothing that supports a finding that the court should have any further action as Deamber Mitchell knowingly caused or attempt to cause physical harm to Mr. Vinegar on August 24th. We're not at the close of the entire case, but Rule 29, again, looking at the evidence in the light most favorable, as we've sat here and looked at the evidence, there's been insufficient evidence, Your Honor, and for those reasons, I'd ask for acquittal pursuant to Rule 29.
Mr. Kaufman?
Thank you, Your Honor. On behalf of Zoe Matthews, I will join in Mr. Lewis's argument. Obviously, the video speaks for itself. I do believe there's evidence that Zoe did strike Mr. Vinegar, so my argument will be to count 1 and count 2.
Okay.
Exact same argument. There's insufficient evidence. There is no way that any injury inflicted on Mr. Vinegar would cause the loss of his life or with serious physical harm. That's all. Thank you.
Mr. Hughes?
Yeah, a little different though, Your Honor. Obviously, you saw the video. Ms. Parks didn't touch this man. And so then you got to tie her together by this whole conspiracy theory that she brought everyone together. There's been absolutely no tie, even weighing the evidence most likely favorable to the state, that she brought anyone together, that there was no messaging, there's no phone calls, there's no specific phone calls to any of these defendants to say, hey, let's go get together and let's go try to find Mr. Vinegar. She has a really valid reason to be there, which is to grab her car keys. But again, the evidence speaks for itself. She did not cause or attempt to cause the death of this man or even cause felonious assault. So I move to dismiss counts 1, 2, and 3.
Okay.
Your Honor, I would just submit that we would argue that the state has failed to meet its burden on count 1, the attempted murder, as to Mr. Floyd. There's been no mention of him involved in any kind of the planning or anything like this. The only time that he's ever mentioned was in Miss Matthews' statement yesterday, where she said that him and Mr. Matthews went with the intention of Mr. Matthews was going to fight him, and then my client backed away. I understand the video and the rest of it speaks for itself, but I don't think that the burden for count 1 has been met.
Mr. Bennett?
Judge, I need some guidance. I know you gave us 10 minutes for closing arguments. I think there's a lot of facts, circumstances, and events that clearly indicate that she was not involved in this case. Counts 1, 2, and 3 should be dismissed even at this stage of the legal process. I could do the 10 minutes now and not do closing, or I could just do a blanket 29 now and do 10 minutes later on in closing. But I won't try to do 20 minutes.
Okay.
What do you prefer,
Tell me
Judge?
what you need to tell me about the motion to dismiss, but
Okay.
I will also suggest to you, if you watch the video and you see somebody raising a bat and bringing it down on somebody else in a light most favorable to the state where all of those people are involved, and I'm not saying at this stage I'm even considering beyond a reasonable doubt, but aren't those 3 things right there enough to get Mr. Hardman over your motion?
No, not with respect to my client, because mere presence at a crime scene does not constitute complicity or conspiracy. That's basically what you have in the video.
But it can, right? I mean, I'm allowed to infer from her presence at the crime scene that she was an accomplice, right? I'm allowed to infer that if I want to.
As a trier of fact, you are. You're also allowed to say that mere presence is not enough, but you are allowed to infer that.
So don't I have to infer that for the 29 motion?
You don't have to, Judge, but you can. It's within your province.
Okay, so we're going to save the rest of our 10 minutes for the
Yes.
closing? Okay. Mrs.
Thank
Straussky?
you, Judge.
You know, I would be brief, I would just join in with the Rule 29, I think especially with regards to attempted murder. My client was assaulted multiple times by Mr. Vinegar. Mr. Vinegar was the initial aggressor. When my client is finally up and off the ground after being assaulted for the umpteenth time by Mr. Vinegar, he does strike him in self-defense and defense of others, on the back and on the buttocks. But there is absolutely no attempted murder and no felonious assault as to counts 1 and 2. So I would join in my colleague's motion for acquittal of those.
All right, court finds the evidence, when viewed in a light most favorable to the state at this stage of the proceedings, is sufficient for a conviction on each of the 3 counts as to each of the 6 defendants. So I'm going to overrule the 29 motion at this point. All right. Mr. Lewis?
Your Honor, I'd ask for 5 minutes.
Okay.
To prepare.
All right, let's do that. Let's come back at 10.
Thank you.
Thank you, Judge.
No, that's in the attorney room.
All right.
We are back on the record. Mr. Lewis?
Thank you very much, Your Honor. On behalf of Deanna Mitchell, defense is going to rest, Your Honor, and would renew our Rule 29 for the same ground.
Okay, noted. Mr. Kaufman?
Thank you, Your Honor. Judge, may I please court? On behalf of Zoe Matthews, Detective Scott Lyons, she was truthful. We had no.
Wait, hold on. We're not there yet.
No.
What?
Are you going to put on a defense?
No, this is closing argument.
No.
Not yet, we're not. We haven't been around the horn yet.
Let me just retract all that.
No evidence on behalf of Ms.
I'm
Matthews?
sorry. I am so sorry. I wasn't paying attention. No.
Happens to the best of us. Mr. Hughes?
No evidence on behalf of Tiffany
Mr.
Park.
Kramer?
No evidence, sir.
Mr. Bennett?
Defense rests, Your Honor, on behalf of Ms. Matthews.
Oh, I did neglect one thing. We didn't talk about, we talked about this a little bit yesterday. We have courts exhibit Roman numeral 1, Roman numeral 2, and Roman numeral 3, and Roman numeral 4, which are the intersection pictures. I forgot to talk about those. Any objection
No objection, waive any defects on Deanna.
to those?
No objections taken.
No
Okay.
objection.
All right, so those will be added to the exhibits.
No defense being offered, no defense evidence being offered on behalf of Floyd Matthews at this time, Your Honor. You're right.
Okay, are we ready for closings?
Yes, sir.
Okay.
Tiffany Parks and Zoe Matthews were facing a tough situation on the morning of August 24th, 2024. Tiffany had gotten into a fight with her long-term boyfriend, live-in boyfriend, Timothy Vinegar. Zoe became entangled in that experience. So they are down, they're angry, and Tiffany and Zoe started rounding up the team. Phone calls are made, texts are sent, and it's batter up. But the object of this game wasn't home runs, it was to kill. And you've seen that from the manner in which Timothy was beaten by these defendants, and through Tiffany's own words that morning in her text message to cousin Chris Ty. Timothy got out of there that day. He made his way up to his aunt, or over to his aunt Paulette's house, getting there around 11 o'clock in the morning. Paulette was one of those people that Tiffany had reached out to, looking for, hunting down Timothy. You've seen those messages or those phone calls. She told you about the phone calls. So as Paulette arrives back at her house after trying to find Timothy, not wanting to be involved anymore in whatever the plans were at that point, tells Vinny, I'm taking you to your mom's house. Mom's house, 25-minute drive away in Mesa. It's confirmed by her Ring doorbell. The time, the location, when Vinny got there, when Paulette arrived, very first thing she says to Timothy, let's go. What also is confirmed from that Ring doorbell, no weapons, no bats. Paulette becomes quickly suspicious as she flees or leaves the parking lot of her apartment complex. She originally saw this black car pull in, and that car pulled out following her. She heads up or down Ronald Reagan Highway. She gets to I-71, heads up to Field Zertle, Mason Montgomery Road. Throughout this whole time, she continues to see this black car following her. She doesn't say anything to Timothy, doesn't mention it to him intentionally. She becomes further suspicious, and as she approaches Timothy's mom's house, it was there she made the decision to detour away, not to bring this to that particular location, to find somewhere public, somewhere safe to be. And so they head up Innovation Way, and they get stopped at the stoplight at I-71 and Innovation Way. That intersection seen in that picture taken from Nate Held that particular morning. As they get there, there's a car in front of them in that right lane. Paulette is behind that car at a stopped red light. Nate Held is in the car behind them. 3 cars. The black car pulls up all the way to the front, as seen in this particular picture. The white Ford Fusion and the white Jeep, blocking Paulette from doing anything. Cars completely surrounding her. Timothy at this point knows they're there. He gets out of the car and observes at that point Corey Matthews and Derek Floyd make a beeline for Timothy. He knows what's going on. He's on the right side. All these cars are on the other complete side of them. And so as Derek and Corey come to him, rather than waiting for them to tackle him, beat him, hit him, he takes a stance and strikes. And then, we know at that point, the other cars are emptied as well. We hear that from Nate. And we also hear from Nate, the bats came out. And they didn't come from Timothy Vinegar or from his Aunt Paulette. They start over on that right side and the area grass there, and Timothy manages to break free and runs across the street. As he told you, it was the women who had the bats at first. But as he's crossing the street, as he's fleeing from the group, from this scrum, as Nate called it, Corey manages to get a hold of a bat. And then they make their way to the west side of the street. It is over there that Vanessa Allen has her camera, or has her phone up, and starts her camera. Which gets us to State's Exhibit 13. From Vanessa Allen's standpoint. I want to play this as I'm talking because I think it is critical to what we're happening. And actually, this has been slowed down on the player. And it's on purpose because you see the bats on the ground. Zoe picks that bat up, starts beating Timothy. She then hands it off to Corey. All the while, Derek already is swinging with all his might throughout his body. And that's crucial right there. Timothy Vinegar on the ground, Derek Floyd hitting him again in his head. They all then flee to their cars. And again, there's mention of Tiffany not being in that melee off to the side. What's important, it's Tiffany who's driving that white Fusion. It drove everybody there. I would submit the evidence would show got everybody there. And they take off from that scene. They flee. They escape back into their cars. They head for home. Their mission is accomplished as they leave Timothy for dead. Fortunately, with the number of witnesses, the quick response, Timothy makes it to Bethesda North. He's airlifted to UC and makes a miraculous recovery to be able to tell some of that story yesterday. Beyond a reasonable doubt, all 6 of these defendants, as either principal players or complicitors, aiders and abettors, encouragers, caused serious physical harm with deadly weapons to Timothy Vinegar with the purpose to kill him. This behavior constitutes attempted murder and felonious assault as charged in the indictments. Thank you.
Mr. Lewis?
Thank you, Judge. May it please the court, Mr. Hartman, detective, my colleagues, and all the defendants here this morning. First of all, Your Honor, I'm going to do my best within my 10 minutes that you've allotted me to focus on my client, DeAmber Mitchell, with respect to the evidence that's been presented. And Ms. Mitchell wishes to convey to this honorable court her sincere gratitude for a fair trial. I find myself really wanting to be as brief as possible with all these great lawyers that I have in the courtroom. And the presentation in this honorable court, we're not in front of a jury. You're the fact finder, you know the law well. I began by saying that the compassion in me and the heart of me goes out to both parents, to Ms. Vinegar and to Ms. Parks, to see their child suffer and endure any type of violence rips at the heart. So I get that. But we're here today because the state of Ohio has a heavy burden, and that burden is proof beyond a reasonable doubt as to each and every element against DeAmber Mitchell for murder and felonious assault. And the court has paid very close attention. DeAmber Mitchell, we didn't have cross-examination of probably any of the witnesses, maybe one I can think of, Judge, and that is because the court has stated more than once, and I can appreciate that the video, the cell phone video that Mr. Hartman just closed in his case with, that was slowed down, State's Exhibit 13, in fact shows what I stated in opening. And the court doesn't have to instruct us. We understand that opening is not closing, but I wanted to be consistent. I wanted to stick to what I said, and my word was true. DeAmber Mitchell, on August 24th, 2024, was in a vehicle with her cousin, Tiffany Parks, and her daughter, Zoe Matthews, not to inflict harm on anyone, not with a plan, not with a motive, not with a scheme to bring injury to Timothy Vinegar, but to actually assist her daughter, her cousin's daughter, who was injured. Let's get her some help. She wasn't in the driver's seat. There is no evidence from the state that DeAmber and Tiffany texted one another. We were a bit confused, and at the close of the presentation of the state's case, my client asked, Mr. Lewis, did those text messages hurt me? And I said, no. He poured a drink on me. He spit in my face. I took the plates off. F him. I don't want to use those colorful words. You have it in front of you. Nothing about a plan or a scheme. On the video, and I take great lengths to remember what Zoe Matthews said, and I thank this detective for being respectful to this young lady, this minor, who found herself in a situation that no child should be in. We did not have a plan to go and hurt anyone. He injured my hand. He spit in my mom's face. We just wanted our keys back to the car that was hers, as stated by Mr. Vinegar. And Timothy Vinegar stated on the stand that, yeah, I squared up. And I understand that to be a vernacular that we use in the African-American community and maybe in other communities. Let's go. Let's fight. It was Timothy Vinegar, Corey Matthews, Derek Floyd. I'm still a little confused if he was going to fight because he said he backed up and they were going to go. There was not a rush. Everyone emptying their cars encircled Timothy Vinegar. That's not what the evidence showed. It's clear that the evidence showed that there was a fight. We don't have cell phone video. No innocent bystander or person in their car started recording prior to what you see in States 13. And I'm still confused as to whether Timothy Vinegar, Mr. Floyd, Mr. Matthews, whether the three of them were fighting. Clearly, as the court cautions the jury, reason and common sense says that if Mr. Matthews, Mr. Floyd had bats, there's no way Timothy would have said, let's go. He would have took off running. And while he's fighting, he says that he's on the ground and trying to get a bat from Mr. Matthews, and he remembers that the girls came out with bats. He didn't say which girls. He certainly didn't say DeAmber Mitchell. And while fighting, On top of Mr. Matthews, as I stated in opening, Deamber Mitchell goes over, pulls Timothy off, and you'll see her make one lunge with her hand. The evidence is not clear whether she connected. The evidence is clear it wasn't done to cause harm, serious physical harm. She's pulling him off of Mr. Matthews. And as she's doing that, others are flailing with bats and swinging. That's reason and common sense. We see it. There's no question there was a fight, there was a scrum, there was a melee, there was confusion. It happened in seconds. It happened in seconds. But the charge is attempted murder, not guilty. The charge is felonious assault, not guilty. The charge is attempt to cause serious physical harm, not guilty. As I close, Your Honor, and again, I have great respect for Mr. Hartman. We've known each other for years. He did what he does for the state, presents his case. But this honorable court, as you wear that robe, as we seek justice, is to continue to hold the state to the burden of proof beyond a reasonable doubt. Can't be led by emotion, can't be led by sympathy, we can't be led by prejudice or passion. My heart aches when I look at that video. My heart ached when I looked at that gentleman in the hospital. That's the humanity in me. But my job as an advocate for Deamber Mitchell is to ask this honorable court to do what it always does. Notwithstanding the personal feelings, Mr. Hartman, you did a great job. But at best, if you want to believe that when Deamber Mitchell yanked at Mr. Vinegar's jacket and took a swing at him, that's misdemeanor assault. At best, and I'm not conceding that, Your Honor, but I am arguing that today, as we stand in this court, that the state, armed with all these exhibits and evidence that's presented, has not proven beyond a reasonable doubt that Deamber Mitchell, with her cousin, who had just been spat on, whose daughter had just been injured, was trying to retrieve the keys, is not guilty. Is not guilty. The reason and common sense went out the door when Timothy Vinegar got out of his car, out of the safety of his car, with his aunt to say, let's go. And with that, Your Honor, on behalf of Deamber Mitchell, I move this honorable court to return a verdict of not guilty. Thank you, Judge Oden.
Thank you, Mr. Lewis. Mr. Kathman?
I want to make sure I'm going at the right time. Okay, thanks. Good afternoon, Your Honor. Edward Kathman on behalf of Zoe Matthews. As I started to say before when I jumped the gun, we had no plan. That's what she indicated to Lieutenant Lyons. And he indicated that he thought her testimony was truthful. I think the Warren County was somewhat confused on exactly how to prosecute Zoe Matthews. She was originally charged with a felonious assault and a complicity. We were in juvenile court, and the charges were then amended to attempted murder. I believe that was done in an attempt to make sure that she was bound over to this court to join the co-defendants. And that's exactly what happened. She's not charged with complicity to commit attempted murder. She's charged with attempted murder, 2 counts of felonious assault.
But the statute provides that she can be either as a principal or as a complicit, right?
I understand.
I mean, they don't have to specify that she's complicit in the indictment, right?
I understand, Your Honor, and that's why we're all discussing this lack of a plan. And I'll try to fit this into the 10 minutes. You know what happened the night before. Mr. Vinegar assaulted and spit on her mother. And there was 2 separate occurrences, actually. The second time, hearing her mother's call for help, Zoe came down and she was also assaulted. Pushed, hit with what she described in her interview as a crowbar, but I think it was more like some type of bar that's used at the sliding door, and she blocked it with her wrist and she had an injury. And Mr. Vinegar leaves. Has the keys that he says are his keys, but are to Zoe's car, and actually have keys to the house on it as well. So now Zoe and her mother are just trying to retrieve these keys. They needed the truck car to be open to get the football equipment to take younger brother to his game that day. Something that Mr. Vinegar alluded to on the stand. He said he was the coach of the team and that, yeah, he had his equipment because he took him to practice. So they had a viable reason
And when you listen to these, the testimony and messages or lack of messages, Tiffany's trying to find her keys. She's calling Paulette Scales, hey, where is he? I need to, Paulette said she didn't say anything about getting the keys back, but there's no mention of, hey, where is he? We're going to do harm. That was something that Timothy's mother, Peggy Vinegar, said, but I will contend to the court that after she saw her son in the hospital, that was an embellishment of the facts. Her statement she made to the police was somewhat different than that. When you look to see if there's some type of working together, some connections, some concert of these people, it's very clear that these cars were not together. Paulette Scales was very clear that she believed she was being followed by a black car. Never saw white cars. Asked her specifically about that on the stand. She said, no, I was paying attention. There was one vehicle. There are no phone calls, text messages between Tiffany, DeAmber, Zoe, any of the females, and the two gentlemen that were allegedly in the black car. What I think is interesting is when you get to the scene, the Innovation Way, one, the car was clearly not blocked in, could have left. Mr. Vinegar got out of the car and, by his own testimony, why are you following me? Yelling at her. Ms. Scales said there was argument back and forth. Mr. Vinegar's timeline gets all screwed up then. They jumped out of the car with bats. He says that happens first, which didn't cause him, in his testimony, to leave. But then, supposedly, after that, the two gentlemen approached and a fight ensued where he swung and the other individual backed up and then Mr. Vinegar runs off across the street. None of this makes a whole lot of sense. What does make sense is there was some yelling going on between Tiffany. She's asking for her keys back. She wants this resolved so she can go on her way. Is it possible to believe that they had bats in their vehicle? Yeah, it is. They knew what they were running into. This is a man that's capable currently and in the past of physical violence toward her and her daughter. You need to take precautions, I would think, if you're going to go deal with someone like that. I don't think that's out of the realm of possibility. Was it said specifically who had a bat, who was doing what? No, it wasn't. But no one said that Derek Floyd or Corey Matthews came up with a bat in their hand. So then the fight ensues between Corey and Mr. Vinegar. And Corey gets hit, and that's when supposedly this goes across the street. When you look at the video, Mr. Vinegar is on top of Corey. The bat is laying on the ground. This melee ensues, and at some point, Mr. Vinegar's on top of Corey. He gets pulled off. He's getting up, and that's when Zoe grabs the bat and strikes him 2 times in the lower back or buttocks area, and then is leaving the scene. And I think it was Corey who then took the bat, and it looks like he hits him 2 times after that, and it's in a similar area. There's no getting around that. Why? She's upset from what happened earlier today. She had every right to be upset with this. As she stated, when you're a man, you don't put your hands on women. You don't put your hands on women. Does it make what happened across the street at Innovation Way right? No, it doesn't. Does it explain why a 16-year-old girl who was assaulted and watched her mother get assaulted would have that kind of anger and take those kind of actions? I do believe it is. It does. It's unfortunate that a disappointing percentage of men don't understand that you're not supposed to put your hands on women. Again, it doesn't justify it. But this is a 16...
Is it Ms. Matthews' defense that she was justified?
I didn't say that.
Okay.
I didn't say she was justified. I said it's understanding that she was upset. She told Lieutenant Lyons her action, she shouldn't have done what was depicted in the video. As she was sitting there, naming the other individuals who were involved, looking at the video, her anger got the best of her. I know this is probably would be more in mitigation, but it's just a totality of the whole circumstance. She's a 16-year-old student at Coleraine High School. She's an honor student. She goes to Butler Tech. She's in a nursing program. She has plans on exactly what she's going to do.
Mr. Kethner, I don't have evidence on any of those things, do we? Or is this in her statement?
It's in her statement. It's definitely in the paperwork that was brought over from juvenile court.
Okay,
Of her
because
back-
I think some of that was in her statement, and I'll consider that to the extent that it's in her statement.
She's a young lady with a bright future.
Okay.
And she's been nothing but respectful in juvenile court in here. She spent an inordinate amount of time locked up in juvenile court before she was bound over and was let on bond. She's had 0 incidents. This court allowed her to be removed from the EMU. She's done very well. She's not a threat to society. She's not a threat to anyone. But to this instance that we're here for today, there was no plan. And as as Lieutenant said, he found her to be credible. I think that's the most important evidence that we heard from that stand, and it's a reason to find her not guilty. We'll just say of all counts. Thank you.
Mr. Hughes?
Thank you, Judge. Morning, Judge. Kevin Hughes on behalf of Tiffany Parks, and I'll be brief. I know that you've heard about this conspiracy a lot. Mr. Hardman used that they were hunting Timothy down, and you've heard the evidence. This is not a plan to try to murder or harm this man. You saw these text messages as they finally worked those in. She's texting D'Ambra. She's mad. Had a drink poured on her the night before. Going through the middle of the night, taking the tags off. I'm mad at him. Chris Ty, again, we don't really know who Chris Ty is. They're claiming to be a cousin. I don't know that that was evidence. But she's venting to Chris Ty. But nowhere in these messages, these phone calls, in this phone, does she say, let's all get together. Let's go find him. Let's go get him. Let's go harm him. Let's go hit him. Nowhere, let's go kill him. She's mad. This man shot a loogie in her face out of love, what he said. So, Ed touched on, yeah, there may have been some baseball bats in cars, in their car. Well, they need to go get the keys, Judge. They need to go find the stuff, the football equipment that this man knows is in that car because he coaches this kid. He knew that kid missed his game that day. He's out just wandering the streets. So where does he go when they have a fight? He goes to his aunt's. If he's not there, they go to his mom's. Because that's where Vinny always goes when they have these fights. We also know that going to the Coleraine Police Department is not likely going to get them a big result. Just using the facts of this case, as we heard, you've got an injured 16-year-old girl that goes to the hospital. The detective says he's going to send the video to him. I'm not sure if he ever did that or not. But they do nothing. Coleraine still does nothing. So out of love, he spits on her face. What do you think's going to happen when they say, I need my keys to get in the car? We're broken up. Give me my keys. And what does he do? He immediately jumps out of the car. He immediately approaches with violence. Vinny starts the fight. Vinny could have stayed in the car that was not blocked in, but Vinny jumps out first. This woman's been beat on for a long time by this man. She knows how he's going to react. So she needs her cousin and her daughter, just come help watch. I need to get my keys back to the 16-year-old's car. Even going back then to the phone to tie back into this conspiracy of getting everyone together, no messages to any one of the men, and including everyone in this room's phone contacts were in Tiffany Parks' phone, of which she did not contact anyone other than D'Ambra. So what the state wants you to believe is that if Tiffany says something, she makes all these others jump. The the dots just don't connect to show Tiffany organized any of this thing. There's no meeting of the minds. There's no expression that we need to get together. no expression of how and what we want to do to Vinegar when we find him. No evidence at all that she rallied the troops, Judge. Again, she had a valid reason to go get their keys to her car to get the football equipment for her son that's missing this football game. At the end of this, you need to return the verdicts of count 1, 2, and 3 not guilty, Judge. Thank you.
Mr. Kramer?
Judge, I'm going to be really brief, so I'll stay right here. I'll reiterate my argument for the Rule 29. I know you've seen the video. There's no evidence presented to show that Mr. Floyd was involved in any of these discussions or any of these text messages. The only evidence we ever heard about Mr. Floyd was that when they got to the scene, the presumption was that Mr. Matthews and Mr. Vinegar were going to fight, and Mr. Vinegar initiated the fight, and my client backed away. There's no evidence that he walked up into the fight with the baseball bat in his hands or anything like that. Like I said, I understand what the video shows, but I don't believe the state's met its burden for all their counts.
Thank you. Mr. Bennett? It's not a congressional hearing. Mr. Kramer can't pay his time forward to you.
I thought he gave me 7 minutes. I got 10 minutes, Judge, that's all. 10 minutes. This is a complicity case against Brittany Matthews, and I agree with Mr. Harmon. It may have been a baseball game, but with respect to Ms. Matthews, she's a spectator. At worst, she tried to interfere with the game, attempted to interfere with the game, but was not successful in doing so. I think she's not guilty. I think the evidence shows that she's not guilty of complicity to attempt murder and complicity to commit the crime of felonious assault with a weapon or without a weapon. So I think she should be found not guilty of all 3 of the charges. Judge, I'm going to concentrate briefly and succinctly on the evidence. I'm not going to mention the law too much. I'm going to point out the evidence that the state produced that clearly indicates that she was not an accomplice to any of the aforementioned crimes. First thing you want to look at is the communication that occurred prior to this incident. Prior to going out in Mason, Warren County, Ohio, on Innovation Road for Mr. Vinegar, what was the evidence that would indicate that this was a plan or there was a meeting of the minds? Patty Vinegar talked about that. She said she talked to Tiffany, and when she said she talked to Tiffany, there was no mention of Brittany Matthews. Mr. Vinegar himself said that Tiffany called people to get him, but he did not say who she called. Paulette Scales, she testified. Paulette said, hey, I talked to Tiffany on the phone. She was talking about what happened earlier, and she was trying to contact Mr. Vinegar, and she heard Tiffany talking to a man. So that wasn't Brittany Matthews. So when you look at the evidence, what evidence do you have from witnesses indicating that there's a meeting of the minds or that she's acting as an accomplice before they go to Innovation Road out in Mason, Ohio, here in Warren County? You don't have anything. So then look at the text messages. You didn't see a text message that indicated that she was involved, had prior knowledge of going out to Mason or to Warren County. No phone calls. There was a mention of a phone call between Tiffany and Brittany. The substance of the call, we don't know what that was. There's no description of that call. So there's no meeting of the minds that would constitute or be indicative or demonstrative of a plan or an agreement to do something to Mr. Vinegar. But you do have evidence that the plan clearly was for Tiffany and Zoe to get their keys back. The state presented that evidence. That's why it's not necessary for the defense to present any with respect to this complicity. The plan, according to the state's witnesses, well, he played the video of Zoe Matthews, and she said there was no plan for her or her mother to do anything but to get their property back and to get their key back.
Better chance of getting your keys back, though, if you kick a couple of baseball bats, right?
I don't dispute that, but that's not my issue, because my client didn't have a bat. My client, Ms. Matthews, I'm not picking on anybody, my client wasn't in the car where the bats were. My client was not with Tiffany. She was not with Zoe. She was not with DeAmber. She's in a separate car. There has no bats. There's no evidence my client gave anybody a bat. There's no evidence my client possessed a bat. No evidence whatsoever. So the bats come from the white Fusion. My client wasn't in the white Fusion. She was in the white pickup truck. There's no connection between her and any bat. The second thing is, what is the evidence with respect to what happened before they get to Mason? Are they following Mr. Vinegar out there because there's a plan to do something to him? No. There's one person following him according to the evidence. There's argument, but the evidence shows there was one car following him, and that car was a black car who the evidence probably indicates it was Derek and Corey. Okay, so what does that mean with respect to Miss Matthews? They're not acting, she's not in concert with them. So if we're in College Hill and he's leaving College Hill and the black car is following him, and the state wants you to believe that they're all following him because they all end up on innovation at or about the same time. That's not the evidence. That's not what Paulette said. That's not what she said. She said there was one car, and that one car was a black car, and nobody else was following her. And she knows that because she noticed the car for about 10 or 15 miles from the time it was on 75 and 275, and it made sense, and she made a U-car, and the car is still following her. So if there's a white car following her, or a truck, she would know it. That wasn't her testimony. The third thing with respect to complicity is the state wants you to believe that, hey, we all showed up and we blocked the car. I tell you what it really looks like. For purposes of time, I'm not going to show it. Your Honor knows the evidence. You've seen it. It appears that they didn't come at the same time. When my client pulled up, she noticed that the white Fusion in the car, and she stopped her car. Her car is nowhere near the car driven by Paulette Scales. She didn't block her car. I tell you who else said the car was blocked? Paulette Scales. I asked her, was your car blocked? No. Now, Nate Helms seems to believe differently, but he's not the driver of the car. And she was able to leave the car when she wanted to. Her car wasn't blocked. It clearly wasn't blocked by my client's vehicle. So she's not acting in concert with the other individuals, and the state of the evidence indicates that she wasn't. So the fourth thing that I think is important with respect to complicity, no evidence of what she said or communicated at the scene before or after the attack. There's been some conversation that there was yelling and arguing between the girls and Mr. Vinegar, and of course there was a confrontation between Corey and Mr. Vinegar, and indirectly Mr. Floyd. No evidence whatsoever about what Brittany Matthews did at the scene. Nothing. Nobody said Brittany said a word. Not one word. So there's no encouragement, there's no suggestion, there's no soliciting, there's no complicity with respect to this act. You look at the testimony of the civilians, you look at the videos, you look at the co-defendant statements, you look at Mr. Vinegar's statement. He never attributed any word or act to Miss Matthews, Brittany Matthews. That's not complicity, that's not a planned attack. And actually, Mr. Vinegar's testimony itself indicates that there's no complicity because what happened because of his conduct. He got out of the car and perceived that there was going to be a fight, so he started the fight. And Zoe said the same thing. No citizens witness, Mr. Helms, Ms. Allen, none of them testified to the contrary, and their videos don't say anything to the contrary because there's no indication from the videos or from the witness testimony of the others when this fight started. Well, we know when it started from Mr. Vinegar. Fifth, if you know somebody has a bat, if you give somebody a bat, if you bring a bat, you, Your Honor, can reasonably infer that this person may have planned to use it. That doesn't apply to my client. That does not apply to Brittany Matthews. It does not apply. She didn't have a bat. She wasn't in the car with the bats. There's no complicity for felonious assault or attempt murder with respect to Brittany Matthews. Sixth, none of the witnesses or none of the videos, I'm talking about Matthew Helens or Nate Helens, Vanessa Allen, Timothy Vinegar, or Paulette Scales, nobody testified about what Miss Matthews did or intended to do. Nobody. Mr. Vinegar did say the girls had the bats. He's not referring to Miss Matthews, Brittany Matthews. He also said that the girls were yelling and arguing with him. He didn't say Brittany Matthews was yelling and arguing with him. There's no complicity with respect to what she did that day. The last thing, which I thought was critical, and I thought it was going to be critical, and I thought it was going to be indicative, maybe even demonstrative of complicity with respect to my client was somebody else, but it wasn't, was they had the downloads, the cell phone downloads that would contain text messages, phone calls, and everything with respect to, I tell you what else the Cell Bright downloads, they showed the location of individuals too. No, that wasn't testified. What was the location of these individuals at 10 o'clock, at 11 o'clock? Did they meet up? Did they follow each other out there? Because that's what they want you to believe, that everybody followed each other out there. Okay, well, you got the Cell Bright, you had your expert. Show us where these people are when they're making these phone calls or having these text messages at 9, 10, 11 o'clock before they go out to Mason. You don't have that. You have argument, no evidence. So did the cell phone downloads indicate that Brittany Matthews was texting with Corey, with Derek, with Tiffany, with Zoe, with Deamber, with anyone, saying, hey, look, discussing Mr. Vinegar, discussing meeting with Mr. Vinegar, discussing confronting Mr. No, nothing. She gave a statement. Nothing about her statement was used. Nothing about her cell phone was used. That's a lack of evidence that common sense and reason would dictate that would show you that there was a meeting in the minds, that there was complicity. Everything that you need to indicate that this woman is an accomplice is glaringly absent in this case. There's one thing that they did attribute as a matter of evidence in this case with respect to Miss Matthews' phone, Brittany Matthews. She texted somebody that inquired about her lack or her not being at work, and she texted back and said, hey, I'm dealing with a family emergency. Does that constitute complicity? No. That was the verbiage, and that was the language that was attributed to her phone. I'm dealing with a family emergency. That's why I didn't go to work. So for those reasons, she's not guilty of counts 1, 2, and 3. The video, and then I'm gonna sit down. What does that video show? That video shows that Mr. Matthews, video doesn't show this, but we know that Mr. Matthews was swung on first by Mr. Vinegar, and subsequently there's a fight. We don't see that on the video. But what we see on that video, State's Exhibit 13, is Mr. Matthews being beat up. You know what else we know about Mr. Matthews? He has a serious brain injury. How do we know that? Because Zoe told the detective that during the interview, and that's the evidence. We also know that Corey is a cousin of Brittany Matthews. So what you see in that video is you see Brittany Matthews observing Corey getting the crap beat out of him with a brain injury. So she attempts to break it up, and she doesn't succeed, she attempts to kick. And I assume that she's probably kicking at Vinegar in order to get Vinegar off of Corey. And in the process of attempting to do so, not succeeding, she falls back because the two of them roll back toward her, and then she falls down. That's what she did, and that's what she's responsible for. And I submit to the court that that's self-defense. That's the defense of another person, and I don't think the state even addressed it. So I don't think the state proved beyond a reasonable doubt that she wasn't acting in self-defense. So I think she should be found not guilty of everything. But the court believes that she was trying to kick him, and she was attempting to cause physical harm, and clearly it wouldn't be serious physical harm, then it would be misdemeanor assault. But I submit that she was trying to defend a third person. And the state did not prove that she wasn't trying to defend a third person.
Thank you, Mr. Bennett. Mr. Strowski? Last but not least.
I'm not going to waste your time or the prosecutor's time or my esteemed colleagues' time by reiterating everything that they've said, but I do want to point out a couple things. You know, I sat there and I listened to Mr. Hardman's closing, and he talked about these phone calls and these text messages, and with the idea that there was a rallying of the troops, and he said to kill Mr. Vinegar. And I sat over there and I thought to myself, I must have dozed off, because I didn't hear any evidence to that effect. I heard one upset woman send one text message to none of these people using vernacular that I unfortunately have texted and used verbally out loud multiple times.
when I've been angry and frustrated. So I thought Mr. Hardman misspoke in his closing. But I don't think he did because he assumes that he knows what was occurring. He assumes that there was a gathering of the troops, that he assumes that there was this conspiracy based upon one frustrated, angry text message, justifiably so, to somebody not even in this courthouse. What I do know is that Mr. Hardman doesn't want to talk about that my client never said a word to Mr. Vinegar, gets out of the car that he was driven in as a passenger while Mr. Vinegar is verbally arguing with people in the street and goes to Mr. Vinegar. He doesn't say a word to Mr. Vinegar. He doesn't have a baseball bat. He doesn't have a weapon of any sort. And Mr. Vinegar starts wailing on my client on the side of the road. It's funny because Mr. Hardman doesn't want to talk about that. And then I think about what Zoe Matthews said in her police interview. That when Mr. Vinegar goes across the road, they get out and they go help Mr. Matthews. Because Mr. Matthews is on the ground getting wailed on again by Mr. Vinegar. Let's talk about that. My client did not say a word, did not bring a baseball bat to this situation. And Mr. Vinegar, and I have to agree with Mr. Bennett, Mr. Vinegar got out of the car. There was no conspiracy plan to kill him, with my client showing up shirtless and Mr. Floyd showing up without shoes on at a location that no one knew they were supposedly going to be at. Because Miss Scales didn't go to Mr. Vinegar's mother's house. She U-turned and was going to some random gas station. So where was this plan going to occur? Where was this killing going to take place? Because it wasn't decided to happen in an innovation way because no one knew they were going to end up there. My client, with the aid of the other people, gets Mr. Vinegar off of him and picks up a bat and is handed a bat to assault Mr. Vinegar to ensure that no one else was assaulted by Mr. Vinegar. Mr. Vinegar was the initial aggressor of all of this. He preemptively decided to strike my client. That's what he testified to. My client never said a word and is assaulted multiple times. I think about, they had his phone, they had Miss Park's phone, they had Miss Mitchell's phone, they had all of these phones. Zoe's phone, nothing. Nothing. I do not believe that my client should be found guilty of the charges against him. And I strenuously do not believe that the state has proven he did not act in self-defense when Mr. Vinegar's own testimony is he assaulted my client multiple times without provocation. I ask you to return verdicts of not guilty.
So Hardman, any final thoughts?
Extend the analogy for one more second. We have an umpire there that morning, that early afternoon. Nate Held pulled up behind this car. Totally unrelated party. There was nothing about any of these 6 defendants. There was nothing about Timothy Vinegar. And what does he tell this court he observed? He observed these 6 people emptying out of their cars and attacking Timothy Vinegar. That was what he saw. He didn't see some innocent walking up to him, Corey Matthews and Derek Floyd. He saw an attack on them. To briefly talk about self-defense, Ohio law says that it's my obligation to prove beyond a reasonable doubt that they don't meet the definition of self-defense. I would argue, first of all, prong 1 of that, the defendant we have to prove the defendant was not at fault, that the defendant was at fault in creating the situation that would give rise to self-defense. I would argue any attempt by self-defense of any of these 6 defendants falls just on that prong alone. They drove over 25 minutes from one location to another to get to Timothy Vinegar. They're at fault for creating whatever situation happened and started. Their self-defense falls on that alone, much less any duty that they would have had to retreat from this scene when Timothy Vinegar gets out of his car and they're on the other side of the car. There's no fear or concern or any need for them to have a confrontation with Timothy Vinegar, and yet they do anyway. They failed. We've met our burden beyond a reasonable doubt to prove there was no self-defense here. You've heard of each one of these defendants. I know the court has seen the video. I encourage the court that wants to look at the video again. But I think the video is excellent evidence of everyone's involvement. Brittany Matthews kicks Timothy Vinegar while he's on the ground. DeAmber hits him while he's on the ground. All at the same time while Derek Floyd is wailing on him with a baseball bat, as is Corey Matthews. After Zoe Matthews took a couple of licks at him in his head, neck region.
Objection, Your Honor.
And overruled.
It's not equal with the facts.
And you have all of that happening on video. That's the best part about this case, is we have 2 innocent individuals who were there at that scene who took video of it. We heard what at least Zoe had to say about that to begin with, trying to deny any knowledge of anything at all happening out there. But what's also nice about Zoe's interview is she also, we obviously have Tiffany's statement, "I want to kill him. We want to kill him." But we also have Zoe stating in her interview that she called people, called Brittany, in order to tell them what had happened the night before, to rally the troops. I would submit to you is a fair enough inference. Within seconds, all 3 of those cars, carrying all 6 of these defendants, arrive at this intersection in Mason and take up arms and bring out bats against Timothy Vinegar. And as seen from that video, as far as the purpose and intent, was to leave him dead there so he couldn't get here, talk about what happened. So he couldn't have the opportunity to be a part of this. But unfortunately, it was so in the open. We see what happened. And we have individual witnesses that talk about how it started. Your Honor, based on all of the evidence, all of the facts that are in evidence in this case, the state has proven its case beyond a reasonable doubt that all 6 defendants are guilty of either as the principal or complicitors to attempted murder and felonious assault as causing serious physical harm or causing physical harm with a deadly weapon. Thank you.
All right, I think it might take me a bit to review the evidence in this, so I think what we are going to do is reconvene at 1:15. So let's plan on being back here at 1:15. If I don't have a decision and I'm still working through this by then, I'll let you know that, but it is my intention to have a verdict by that time.
Thank you, Judge.
Anything else? All right, that's all. We have all the exhibits. I have Roman numeral. I do not, sir.